All right, we're going to try this again and hopefully get George Saldana in here. We're going to be talking about Rule 12 requests and how to fill them, what they are, how they work, and just wait a second. And we want you guys to be following along. And to look up the rules first, go ahead and Google Rule 12 Texas and get that PDF open. We're trying to get George in here. So, but go ahead and Google Rule 12 Texas, and it should be a PDF that shows up. I found it under txcourts.gov whenever I Googled it. And George, I sent you an invite before I started the video, so it should allow you to pop in here. But yeah, if you're waiting, just go ahead and, okay, just give me 1 second. Go ahead and get this PDF open, and we're going to read through it. So at the top of this PDF, it should say Rule 12, Rules of Judicial Administration, Rule 12, Policy Access, Public Access to Judicial Records. So this is very similar to the open records request that we're probably familiar with. You can use those to request government documents, communications. You generally will do that through a spokesperson with the city or county. They generally have an open records division. That's pretty well known. A little lesser known is something very similar that deals with judicial records, which is Rule 12 requests. All right, and we got George in here. Hopefully folks have their Rule 12 PDF pulled up. Yeah, Steven, I'll get some sleep whenever these judges start behaving, so we'll see what happens first. But all right, you ready? All right. So, George, what I did was I had folks open up the PDF because I think we all need to kind of be referencing this. What's nice about the Rule 12 requests, which are similar to, they operate similar to open records requests, so it's not a bad thing to kind of think about them as being very similar in your head. But the difference is judges will not answer your open records requests. They will only respond to Rule 12 requests, but they are very similar, so you don't have to kind of relearn everything. You just need to know a little tweak of the language, read this PDF. What's nice about the Rule 12 request, I think, is that it's actually really straightforward. If you look at the Texas Public Information Act, that's like several dozen pages long. It's really complicated to understand that. The PDF that we have in front of us for Rule 12, how long is it? Several pages. It's not that long. You can read through it in about 10 minutes or 5 minutes. Again, you know, pretty straightforward. So whenever these judges try to come back at you and confuse you or say that, you know, you can't access their records, it's pretty easy to go through here and say that, yes, you can. All right, George, did you leave the chat? George, okay, so I'm gonna get him, I'll get him back here. I got it. He's gonna come back. Accept. Okay, so he's coming back. All right, so let's get started here. I want to start by reading the beginning, real basic stuff. At the top here, it says, the purpose of this rule is to provide public access to information in the judiciary consistent with the mandates of the Texas Constitution, that the public interests are best served by open courts and by an independent judiciary. And this is an important sentence, I think, this next one. The rules should be liberally construed to achieve its purpose. So right there at the very top, you have this kind of mandate that the public has a right to government records, including judicial records from the judiciary. And here, again, at the top, it says It should be liberally construed to achieve its purpose. That means that the person who is on the receiving end of the court, they need to do their best to bend over backwards because the burden's on them. The law, the way it's written, again, the rights that we have through the Texas Constitution put the burden on the government to release documents to the fullest extent that they can. And what kind of stuff can you ask for? So it's important to understand what you can and what you can't ask for. Um, Obviously, when you're dealing with stuff with lawyers, there's attorney-client privileges. So just like with open record stuff, you'll find that same kind of barrier. Sometimes there's a communication between an attorney and their clients that can't be made public. I think that's reasonable. Also, the records that you seek through Rule 12 are things that are done through the course of regular business, as they would say, and not related to their kind of adjudicatory powers. Let's see, adjudicatory powers, if I'm saying the word right. So that leaves a lot of things open. So that means all the emails that your judge sends to their colleagues. Hey, come to this birthday party. Did the bailiff show up on time? Just communications amongst the judge and the associate judge and the people in the courtroom are things that you can get a hold of. So here's my point. Often when you request these Rule 12 requests, what they'll try to do is they'll say that there are no responsive records. And that's because either they're ignorant of the law or they're willfully ignorant of the law. But the point is, if I ask for all emails from a judge over the course of a week, there are going to be emails. There is no way that judge is not sending and responding emails to their staff. And those are the things that you have access to. So who do you not have access to? Well, Rule 12 doesn't apply to everyone inside the courtroom because the bailiffs, as we know, work for the county. And so if you're trying to get communications from the bailiffs, even though they work in the courtroom, that's an open records request. Although you can request, there is some overlap and often you need to kind of do both together. If I want to see who's talking, I'm going to want to do an open records request on the bailiff's communications to the judge, and then I'm going to want to do Rule 12 requests from the judge to the bailiffs, right? So those are two separate areas governed by two separate rules, but they're very similar. And so, again, if you're just joining us, I want you to Google Rule 12 Texas, open up this PDF and familiarize yourself with it. Again, it takes, 5-10 minutes to read it. It's written very simply, and you can learn very quickly what your rights are. All right, so what do you want? What kind of stuff would you want to ask for? Basically, remember, these are your emails. So if you have a case going on, you have a right to see what they're saying about you, if they're talking about you. And don't hesitate to do that. A lot of people, get kind of nervous about asking for a judge's emails. There are emails, those are our servers. This is our tax money. I'll give you an example from my personal experience. 3 years ago, when I was facing bogus harassment charges, I was arrested, and I had a really interesting situation where I was down in the Tarrant County Jail, and a magistrate judge named Mark Thielman waited until the room was empty to give me my whatever that initial, here are your options. Here's, but basically he waited till the room was empty and then told me that he was friends with the family that was accusing me of harassing them. And I found out afterward that he had placed my child on a no contact list. So his behavior was very unethical. He was using his position to kind of intimidate me. And so one of the things I did is I went back and I requested all the emails that he had sent over the course of that week before and after. I was just curious, what are you talking about? Who are you talking to? And he responded by saying that some of the communications he couldn't release because he was just citing probably bullshit reasons, but he did release one email that showed that he was talking to another magistrate judge about me and informing them that he was friends with the victim. And so that was, again, highly inappropriate, kind of telling his friend, hey, you need to stick it to this guy. I'm friends with, their victim. But I don't know what else he had because he withheld that. And so I went ahead and appealed that, and we'll talk about that today. When you appeal, when they come back to you and say that these records don't exist, and they're lying, and most of the time they're going to be lying because judges refuse to share their emails, and I'll talk about that later today. In Tarrant County, we basically have seen no judge release an email that they've sent, even though we know they send emails, right? Judges are sending emails. They seem to think they're above this law. But so I went ahead and appealed it, and the way the appeals work, you'll be notified by that first person that they don't have to release the emails. And then you can appeal to the Office of Court Administration. So that's what makes this different than the open records requests, which are appealed basically to the Attorney General's office. You're going to communicate to the Attorney General's office, and you guys have this right. Keep this in mind too. Whenever the Open Records Department of a county denies you access to records, you can contact the AG's office directly and give them your point of view. We're not lawyers. We can't always cite, case law. If you can, even better. But you have every right to notify people during your appeal of why you're appealing. And here's my point. Whenever I appeal stuff, I always include information about the misconduct. And that's just my personal thoughts. Whenever you are reaching out to another, I think we have an obligation to voice and describe misconduct at every point. And so whenever I appeal that, Mark Thielman's case, to the Office of Court Administration, I included like a full-page letter supporting documents related to my case. And my case was kind of interesting because I had a very wealthy family that was using their influence to make me out to be a criminal. So I included all that information. I said, Mark Thielman's part of this. He's part of this wealthy family. And so anyway, whenever you guys get into this process and they deny you access to your records, I would almost always appeal. It's your right to appeal. It's not that hard. You just got to write a letter and send it off to Megan Lavoie. But I would take the time to really explain what is the misconduct you're looking at. Anytime you can get someone, because these are judges that are going to read these letters. They're going to put together a panel of judges that's going to read this letter, and at least you're getting that information out. It's worth it. And so that was my and the other experience I've had with Rule 12, and what makes it really interesting is open records, as imperfect as they are, there's a lot more transparency with that process because you have dedicated offices usually in each county. You have people who are working full time. You have a lot of eyeballs on these requests. And it's harder for them to hide stuff when it's done at that level. The Rule 12 stuff is easier for them to cover up stuff, and they will do it because you're basically just asking the judge to say, please hand over, this email. And sometimes you're asking the judge directly, and sometimes you're asking their coordinator, but there's never a third party. There's never a third party that's going to come in and make sure that they're actually fulfilling these requests. So that's where I really encourage folks to start exercising this right and to kind of be aware, because you deserve access to your emails, and every time they try to block it, just go ahead and fill out that appeal and say, this judge has basically refused to release anything I've ever asked for, which is likely to happen. They don't think that they have to give their emails up. So, and we've witnessed in Tarrant County, we've witnessed a lot of inconsistency with these Rule 12 requests, where we can kind of guess what they're withholding. Sometimes if you have a copy of a document and you request it, it's a good way to kind of catch them lying, because you can, once you have that document. And one thing I've done with Jesse Navarro's court, because he has refused to basically release anything, is I've gone to the point where I've kind of had to back up, and I'm going to say, okay, listen, you're clearly not going to follow the law, so I'm going to have to kind of teach you like a baby, right? We're going to do baby steps. I have emails that I know have been sent to the judge, and I have emails that I know he's been CC'd on, and so I'm requesting those. And I've even notified him, if you do not, release this email, I have a copy of it. And when I send my appeal to the Office of Court Administration, it's going to include evidence that you're withholding documents that I have a lawful right to. And again, this is kind of a long game that we have to play with these people. But imagine if there's a pattern of them getting a dozen, 2 dozen, complaints or appeals that are very clearly, the judge withholding information because you've proven it. You've shown, I've asked for emails from this period of time. They say there are no emails. I have a copy of an email from that time period. I've gotten, maybe I got it through an open records request. Maybe it was, maybe I sent it, so I have a copy of it. It's that simple, right? And so I've gotten to that habit, and I'm going to teach these judges how to follow the rules. And it's very time consuming and frustrating, but I think it's worth it because it's just one more level of us holding judges accountable and reminding them that they work for us. Eric Clark said, read through the entire thing and make sure, especially 12.9. And again, the nice thing about the Rule 12 is it's not that long. It's really written very simply. They did a good job. The language is not complicated. It's very clear. It's not dense. You can read through this, once in a few minutes and understand really clearly, what you can get and what you can't get a hold of. But the fact is, this rule exists to release communications. And when they say that there are no communications, they're almost certainly lying to you because there are certain, there are things that they can withhold, but that's not going to be the majority of emails that judges are, typing up every day. Oaths of office, that's another good thing to learn. If you have a busy retired judge or you want to get a copy of a request for assignments or an order of assignments, you can do that, but you have to do that through the administrative judge of the region. So, part of the trick is finding who is the custodian of the records. I ran into this issue with the magistrate judges in Tarrant County, and when I say magistrate judges, I'm specifically talking about the judges who are in the Texas Tarrant County Jail intake. With the people who are arrested there. And so when I emailed them, actually, this is back to the Mark Thielen story. I emailed someone who basically I thought was the court administrator of the magistrates, and they responded intentionally unhelpful. They were saying, I'm not the custodian. And I got so frustrated, I eventually called her and I asked her, I said, listen, do we have a right to these records under Rule 12? Do I have a right as a Tarrant County resident and a U.S. citizen? Do I have a right to these judicial records? And she said, yes, you do. I could tell she was getting nervous. I was also probably sounding a little angry. And I said, is what you're doing obstructing my access to documents that I have a lawful right to? And basically, I put her in a corner, and she finally got back to me and gave me the email of the magistrate judge that I was asking for. But that's, again, that's a bizarre situation. It's not always really clear who has the records, and sometimes they'll be intentionally, they'll try to obfuscate, hide, who has the records. So when it comes to stuff like oaths of office and requests for assignments, order of assignments, that's the administrative judge. That is David Evans, and that is his secretary, Tracy Kemp. And so I'll give you guys Tracy Kemp's email, because a lot of stuff you're going to be asking for, maybe you don't live in our region, but a lot of stuff you're going to ask for is going to come from the secretary of the administrative judge of the region.
So can I jump in real quick?
Yeah.
So one of the things I did find out in my journey is that the court coordinator, which is usually the right-hand man of the judge, the court coordinator, court clerk, one of those, the judge is responsible for his records. His office is responsible for maintaining those records. So the court coordinator or the court clerk, and I would go to the court coordinator first. The court coordinator in my instance told me that she didn't have to give it to me. And then when I told her, hey, look, the judge is the custodian of records, and if you would like, I would like to speak with the judge then, right? Of course, they don't want you to talk to the judge whatsoever. So then it throws it throws it back on them. Hey, look, well, I need you to tell your judge that they're the custodian of records and that they need to release these documents to me. So that's how I've been able to kind of circumvent that issue is because I don't know if some of these court clerks or their coordinators, they even know that the judge is the custodian of records. And I found that out through talking with the SCJC.
Okay.
Is that each judge is responsible for their own records. And if you're not going to let me talk to the judge, well, then somebody from your office needs to provide that.
Yeah, and again, each court's a little different. Sometimes you're going to talk directly, you're going to email directly the judge, and sometimes you have to email the coordinator. I've noticed in my experience that when I email the judge, they ignore me. And so for whatever reason, the coordinators tend to be a little bit more helpful, but they have an obligation to fulfill this. They have to respond within a period of time. When you just like open a records request, right? They have to, and you can put them on notice. It's been 30 days or whatever it is, you haven't responded. I think it's similar. I believe they have to respond, and then they have a certain window after that to actually fulfill the request. So they have to follow those guidelines. Tracy Kemp, her email is thkemp, K-E-M-P, thkemp@tarrantcounty.com. And this is how we found out that Bill Harris had no order of assignment. So Stephanie Rima, a couple months ago, reached out to me just because of some articles I'd written, and I kind of explained how the Rule 12 requests work, and she did one, and she found out that her client, was jailed for 2-3 weeks from a judge that had no authority and no assignments. He wasn't even assigned to the case. But we would not have known that if we had not requested these Rule 12 requests. So again, they're pretty practical. And even if you're just curious, what is, my judge, is probably talking about me. My judge is probably talking to someone else about me. Is there ex parte communication going on? Go ahead and ask. Don't hesitate. Those are your emails, And again, what we're finding, let's talk about Tarrant County. We've seen how these judges, Beth Polos, we did a large Rule 12 request and we got a lot of emails, but for some reason there was 0 from the judge. And the clerk even said, well, Beth Polos didn't email anything about this case. It's highly unlikely. What we're seeing is 0 emails being released by these judges. And so that just points to their arrogance. They don't believe it's not hard. I guess for us, it's not hard to imagine why. We know judges are incredibly arrogant, right? They cannot imagine that we have the right to demand them turn over their emails, right? That is what they're supposed to do, and that's what we have every right to ask for. We've seen Judge Jesse Navarez. He's taken to very childish antics, even though we'll give very specific Rule 12 requests. He'll come back and say, your request is too vague, be more specific. And it doesn't matter how specific the request is. Clearly, no one's asking him like, hey, send me some emails, and we're sending him clear directives, and he's just choosing to be childish about it. And so every time he does that, that's kind of why, again, I've taken to they're going to act like a baby. We're going to take baby steps, and I'm going to slowly teach them how to follow the rules. And eventually, I'm going to get a copy of every email Jesse Navarez has ever sent or received. That's my goal. I'm going to get a copy of every email Kevin Schmidt has ever sent or received. And you can use that just to review them, just to catch them doing things that are unethical. That's also going to be evidence. You can use misconduct if you need to. Honestly, I don't care what your reason is. If you want to read those emails, ask for those emails. Yeah.
Hey, so one of the things I've done Rule 12s on are hallway cameras in the courtroom. Because if you're in this fight, you always have opposing counsel, or you have a litigant, or you have somebody acting the fool outside the courthouse. or outside the courtroom, I'm sorry, in the hallways, which a lot of us record in the hallways, which that's your constitutional right to film in public. I still believe you can film in the courtroom. That's just my opinion. But one of the things that I think people have lost sight of, and you were touching on it, is that you're entitled to these records, right? It's our taxpayer dollars that pay for the judge's retirement, which is his pension, right? Not many people have pensions anymore, but judges do, right? Teachers had pensions, cops had pensions, firemen had pensions, and they were all taken away, but the judges still have pensions, right? And all of those pensions, retirements, come from the taxpayer. Our internet, the internet that runs through that courtroom is paid for.
Electricity.
Right, the electricity, right? The renovations, if they got to renovate the courthouse, all that comes from taxpayer dollars. Not just that, but their computer hardware, their software, all of that stuff. The Zoom. My biggest issue with Zoom is that's taxpayer funded money through the Office of Court Administration. We are paying for that Zoom. So when they don't let litigants use that Zoom, or court watchers for that matter, to use that Zoom, why are you using taxpayer money to buy all these Zooms for all these courts, but then mandating the public come in because our courts are open? It says public access. It doesn't say courts are open. It says the courts are open for public access. And now we have evolved. We've moved to 2023, right? And we all have computers, laptops, everything. We can search Rule 12. In 1985, if George and Edward try to go look for Rule 12, the rules of judicial administration, we'd have to go to the law library, or we'd have to go and find somewhere at the OCA that would have this Rule 12. When at our fingertips right now, we have the ability to find this stuff, research it, and implement it and put it into practice. But when these and this is why I encourage everybody to do Rule 12 request, right? Is because we need to take back our judicial courts. We are funding this, and if we're funding these courts, right, we're paying for it with our tax dollar. Every dollar that we spend goes to Tarrant County Courthouse, and we can't receive the records. We have an issue. Then maybe
I think we have. I think we have a civic duty to exercise this right. This one's really important because there are some big battles that we're fighting. We're trying to change the whole system so that fit parents are allowed to parent their children. We're trying to stop family courts from using quasi criminal allegations outside of criminal court where we don't have the same rights we would have. We have some big constitutional things we're fighting, but on the it's all important. On the lowest, on the lower end, just asking for an email and then insisting that you get it, and then when you don't get it, appealing it and describing the misconduct and how crazy it is that how can a judge not have sent an email over a week, right? That makes no sense. So basically this judge is lying at that point, right? So this is but every time you do that, we're reminding these judges how to work for us. We're slowly retraining them that they're not the boss. They work for us. They're an employee of the government, and we pay them.
I mean, you're a public servant. You ran for this election. We didn't put you there. You wanted this position, and now you have to eat what you asked for. And if you don't know the rules, it's our job as the taxpayer, as the person, the litigant, to tell you, hey, look, there's Rule 12. You guys need to follow this. It says this. I understand you haven't been approached with Rule 12 in the past, but now it's enforceable, and it's like going to church, right? You go to church and you look for religion. You should go to your courthouse and look for justice. And unfortunately, in these courthouses, there isn't justice. And our only mechanism to try to find justice is to dig into records, right? The judge should know this. If you're going to run for that position, if you're going to run to be a district court judge, I would make damn sure I knew that job, right? I wouldn't take on a job that I don't know how to do, especially when you're dealing with people's families, right? If you are running just for the status of being a district court judge, right? That's wrong, because now you're putting a lot of families, within your grasp. And if you're not following the law and you're going to violate and you're going to go after, you've been arrested. I've been arrested. Tons of other parents that I know have been arrested due to harassment, right? Because they say we're harassing when we're trying to get from point A to point B, which is our children. And now these judges are taking sides. I've heard in the past, and I've actually seen it, where a lot of these cases are already adjudicated before you step in the courtroom. Everybody says it. I've heard it. But it wasn't until I actually saw it here in Bexar County. I physically saw it. Pro se litigant walked in, trampled within the first minute, right? Because the lawyer and the judge were BFFs. The judge would babysit for this lawyer. And so now, look, justice, it's not worth the piece of paper it's on. You have a court order and it's not enforceable. And then now you have judges taking out hits on parents that are, digging a little deeper, right? Just to see and have a relationship with their child. It's our duty. You're absolutely right. It's our duty to hold these people accountable. You asked for that job, now you do it. It's just how I think.
No, I love that. I'm going to tell you a couple, stories. A lot of the stuff that I've reported on over the past maybe 2 years now that's been kind of heavily focused on judicial misconduct, I found through Rule 12 requests. So if you guys just, if for no other reason you just want to go digging and be a detective and this stuff can be kind of fun. What have I found? Well, just because I've, learned to exercise Rule 12 requests, I found out that there was a judge who was assigned as a senior judge to 100 criminal cases, and he was not a senior judge. And first of all, I found out that he was, he basically, okay, I forget the order of things, but, I found all these order of assignments that said senior judge. And that was signed by David Evans. So our administrative judge was falsifying government documents, giving Daryl Coffey a title that he did not even ask for. And I know this because in order to be a senior judge, and I love digging into, senior judges because they're like the most corrupt, openly corrupt group of judges you'll ever find. They have to ask for an appointment from the Supreme Court. So they have to send a letter. And that letter has to be accepted and signed. And he never even sent the letter. He didn't even ask for this title. But he was given this false title from David Evans 100 times. And that includes felony cases. That includes, large criminal cases that sent people to prison were presided over by a judge with a fake title. I have found, criminal judges that took time off work to go give a speech to their police buddies. And if you're an elected judge and you're being paid to be a judge, and there's a statue being built, and you're taking off time from work to go say some words and making us pay for a replacement judge, that's not a valid reason for missing work, especially when your job is that important. I found a judge in our region who held 2 positions of profit at one time, and that's illegal. So for a government official, especially a judge, to hold 2 governmental positions of profit at the same time is unconstitutional. And the reason he did that was because he elected to be a senior judge, which is a paying position, and he was given that title while he was still active. So there was like a month where he was an active judge and a senior judge. Both positions pay money, right? So just, you have to kind of know what you're looking for. I can find judges who are presiding over cases they're not qualified for. I can find, I found judges who, who never presided over, family court, and all of a sudden they're doing that as a retired judge. All that kind of stuff. Once you start asking for these documents, you can kind of look at, it's like the back room, the stuff you would never see, all the paperwork that happens in the back, they're not even, I think a lot judges aren't even aware that the public can access this stuff because some of it's been so embarrassing. I can't imagine they kept these records.
Yeah, and um, not just that, but a lot of these rules and a lot of these laws. And before I forget, I want some of you guys to, if you read Rule 12 again is the rules of judicial administration. It's not Rule 12 of the Civil Rules of Procedure. When you go over Rule 12, right, I also want you to look at Chapter 37 of the Penal Code. Chapter 37 of the Penal Code. Because you're going to see definitions in Chapter 37 of the Penal Code, which goes over perjury and other falsification, that you're going to see in Rule 12. So Chapter 37 of the Penal Code and Rule 12, those definitions align, a judicial record, right? And so everybody always talks about perjury. And here's another thing, guys. Perjury is criminal. You're in a family court. I have my opinions about where things should go, and I'll just leave it at that. But when you file for perjury and aggravated perjury, that goes to law enforcement. That goes to your bailiff. A lot of people think that bailiffs are just there for the judge. Well, no, the bailiffs, by the government code and by their policies, are supposed to still uphold general law, which means you can still file criminal complaints with the bailiffs. They are just not there for the judge. They are a part of the county they work for. They don't work for the judge. They don't work for the courthouse. They work for the county of wherever you're at, Tarrant County, Bexar County, Harris County, or whatever. They have jurisdiction inside that courtroom. They don't have jurisdiction outside that courtroom. In Harris County, they actually have Constable Precinct 1 who has jurisdiction over security of the building. So when I did my Rule 12, I had to go through Constable Precinct 1 in Harris County to try to get those cameras. What I found out is no cameras exist in that hallway, even though I see the little black bubble. So they're telling me that that little black bubble is just there for show, that there's no camera inside of it.
Yeah, and I ran into that recently when I was doing an open records request. And I'm not even quite sure, what the correct way to request it is, because I would assume the county runs those cameras, but I sure saw a lot of cameras in the courtroom, but they were very clear that that there are no cameras in the courtroom and they can only provide footage from the hallways, which they did.
It's funny because Harris County denied me, and when Edward was talking about how they lied to you, they absolutely will. One of the lies that first kind of juked me was, well, we don't have to give you placement of cameras due to the security of where they're located, because some of those cameras are for security purposes only. And if it's going, and you'll read it in Rule 12, I forgot where it is, but it does say that they don't have to give it if it's going to mess with security of the courtroom. And I get it. I asked for the security camera footage in our courts, because in Harris County, you do have a few cameras in some of the courtrooms. And even though those aren't a part of the official record, because there's only one official record, and that's with the court reporter, I still said, send me those cameras. Send me those camera angles in the court, whether they pick up audio or not, because I want to show it. If some of y'all know that are watching or don't know, I was held in contempt for trying to litigate my case. The judge walked over me. I told her I was trying to produce a record. She sent law enforcement over to basically throw me out of the courtroom. They didn't handcuff me, but two officers escorted me out and said I was being held in contempt. The judge said I was being held in contempt. I was being detained from a public place while I was trying to conduct business and I was trying to litigate. So I asked for that camera footage, right? And of course, they didn't want to send it because it shows what I just described. But this is the exact reason why you want to do Rule 12 in your courthouse. You want to look for cameras. You want to look for emails. I want to know if that judge talked to the amicus on his email. Our taxpayer funded money
Mm-hmm.
pays for that email.
Mm-hmm.
TH, what was her name? TH what?
Oh, are you talking about the civil rights
No,
attorney?
no, no. The administrator that from Tarrant County.
So we have David Evans and Tracy Kemp as the secretary.
So both of their emails, if they end with @tarrantcounty.com,
Mm-hmm.
that's a taxpayer funded email. They
Mm-hmm.
didn't make that email themselves, right? So we're entitled to that. They're public servants. It's
Mm-hmm.
just like a police officer must give his name and his badge number, right? He's a public servant. Firemen are public servants. You can ask from all of this information from which taxpayer funded money is going to, and you should. Those are just other ways to get what you need, especially if they're coming at you, especially if they're retaliating because you're doing stuff, which we both know from experience, being arrested, that we are being retaliated against. We just have to put it together. A lot of people are under the impression, just do what the judge says, the judge rules. He doesn't have to follow the rules. He can even break the law. A lot of people think that. Judges can even break the law. The judges can absolutely not break the law. Penal code, code of criminal procedure, the government code civil and the code of civil remedies code. I mean, all of these codes they can't break, right? And again, we live in 2023 where if I have a question, I should just go look up what Rule 12 is on my iPhone, and I have it. But instead, what they do is they like to take things under advisement, and I'm going to go back and I'm going to sit on this for a week and see if George and Edward Brown forget about it, and then I'm going to rule against them, and then it's going to be swept under the rug. When you stay on top of them, when you keep pushing, when you start, and they know that you're not going to go away, that's when you start seeing things start turning for the better.
So I wanted to do something fun. Folks, if you're watching, can you get your computer out? Of course, you're probably already on your computers. Get your email open and take a minute, because the first thing you're going to have to do is to look up the email of your court coordinator, right? So think of your favorite judge. And of course, I'm being funny when I say your favorite judge. We all know who our favorite judges are. Go to their website, and you may or may not be able to find it. So if you have to go back and figure it out later, that's okay. But go ahead and let's go through this process. Let's say that you can find the email of the court coordinator of your favorite judge, and we're going to email them right now. And I've done this. I do this routinely with the 231st. We're in a nice little lovely tug of war where they're saying that I'm not being specific, and I'm having to go back and redo this, but. So I'm going to email the coordinator, the 231st, Michael Kapelovitz, and you guys get your emails open and type in the email of the coordinator of the. And if you don't have that, I'll have you guys email Tracy Kemp. Does that sound good, George?
Yeah, we can.
Let's do
it.
If you don't have an email, if you don't have a judge of mine, I want everyone to email Tracy Kemp, and Tracy Kemp's email is. THKemp at tarrantcounty.com. THKemp@tarrantcounty.com. And in the subject line, sorry,
is it CAMP or KMP?
So T as in Tracy, H as in hamburger, and then Kemp, KEMP, all together at tarrantcounty.com. And on the subject line, you're going to write Rule 12 requests. I mean, you don't have to, but it's kind of just polite to be very clear about what you're about to ask. And let's say, hello, Tracy. The language you use there's different ways to use this language. You could say, I have Rule 12 requests, here it is. I've just gotten in the habit of using this format. Please find by this email my Rule 12 request for all emails sent to and from David Evans from, and you guys pick a date. I'm gonna say 10/1/23 to receipt of this email. And I like using that because if you're trying to get the most current stuff, you basically say to receipt of the email. It'll give you the most current information. Again, I said, hello, Tracy. Please find by this email my Rule 12 request for all emails sent to and from David Evans from 10/1, 10 the 2023. So basically October 1st, the receipt of this email. Or you guys do however you want. Email your coordinator of your favorite judge. Ask them something very similar. And here's what I would do. I would ask for emails within a window of a couple days. Don't ask for a year's worth of emails. You can if you want, but that's going to obviously be a huge workload burden on them. But I would say a week. And the reason I would say a week is that's reasonable. It's not going to be a crazy amount of emails, right? But it's enough that if they come back and say there are no responsive records, you know that they're lying, right? That judge has received emails. That judge has given emails, right? How many emails do we send? How many emails do you send in a day, George? 100. More than that. No, I know you sent a lot more than that. You probably sent 100. You probably get 200.
Yeah. So, and one of the things you can do to set it up is send an email before, wait a week, and then ask to see if, and do your Rule 12. That way, you know if they're going to lie to you or not, because now you've given them a little bit of bait. You've sent that email, and then now you're coming a week later, coming back to check to see if that email exists or not. Mm-hmm. And that's a real quick way to find out whether they're going to lie to you or not.
Yeah. I'll give you some more pro tips. I love the game of, catching these people. I know that Jesse Navarez was communicating with the Open Records Department because I was asking for stuff related to their bailiffs. There was, a complaint I filed on them. And, the Open Records Department of the county is currently hiding, my cat's jumping up here, but basically my point is ask for communications sometimes between the Open Records Department and this corrupt judge. If you know that they're trying to hide stuff, like for instance, if the Open Records Department appeals something, they've talked to that elected official, right? They generally are going to, work with that judge. That judge and say, oh crap, please don't release that thing. It's really embarrassing. Can you appeal it to the AG? So then what I do is I ask for communicate copies of all emails between that judge and the Open Records Department. I want to see what are they saying. So always think about how do you catch them talking about you, right? What is the bailiff, saying about me? Are they communicating with the county? And you can really kind of get them kind of scrambling to cover their tracks. And when it comes to Open Records stuff, I think you can really catch them in a way because it's harder for them to circumvent, the county, which is usually the district attorney's office. They can kind of play games, when it's just their coordinator emailing you. But if you can capture them, talking to the Open Records Department and whatnot, that's kind of, so just kind of think creatively, think out of the box, and don't be afraid to, if you have a good hunch, don't be afraid to go for that. You can also use keywords are really useful, for Open Records stuff. I can ask for all emails from an elected official to have keywords, and that'll catch, it helps them be more efficient and catch certain things. But yeah, you can find, oaths of office, from the administrative judge, communications, requests for assignments, orders of assignments, anything related to your case, or if you just want to go fishing, just to catch these people being crooked. This is a great tool.
One of our advocates, we found out who the Supreme Court justice is over the SCJC and Blacklock, Justice Blacklock. And so they did a public information request from Justice Blacklock and the SCJC pertaining to judicial misconduct. If there was any emails between the Supreme Court and the SCJC talking about anything. And this was right after we all traveled to Austin to talk about judicial misconduct. It happens every 2 years. And when we went there, we waited a couple weeks, and then one of the advocates reached out and said, hey, what was the report that was given from this public meeting to the Supreme Court? Or did the Supreme Court ask the SCJC what happened at that meeting? Because remember, Supreme Court Justice Blacklock oversees that oversight committee. And there was absolutely zero emails to and from is what we got. So how does the SCJC, who's the oversight committee, give a report to the Supreme Court? Or how does the Supreme Court check the oversight committee if there's no emails back and forth?
I think you caught them lying.
What?
I think you caught them lying. You're saying it's not possible that there's no emails, right?
I don't think so.
Yeah.
And if there's no emails, then what oversight is being oversighted?
Mm-hmm.
If I'm in charge to look over a managing construction crew, and there's no cell phones, there's no email conversations, there's no text messages.
Yeah, they're radio silent apparently, right? They're off the grid. They're living like hermits, you know. They're
So
out there.
Our SCJC is just running wild, right?
They're on a commune. They're just out, a bunch of hippies out on a commune. There's no technology out there, you know. No, I mean clearly they're lying, and you know it's ridiculous for me, you know, to send. You know, again, I'm going to pick on Jesse because he doesn't follow the laws for anything. But you know, if I'm asking for all emails sent to and from you over a period of a week, and there are no responsive documents, I mean, you know, you're lying to me. So, but the fact that they're so brazen is why I encourage folks to do this. Get these judges. Let's retrain them. Let's teach them how to, you know, release information, and again, take baby steps. You know, just ask for 1 week of emails to and from. And when they lie and they say that there are no responsive, you know, emails, appeal it and then do it a different week. And when they lie and say that there are no responsive emails, appeal it again. Because we want the Office of Court Administration to start getting a trickle and then a flood of these emails that are saying, what's the point of there being a Rule 12 law? Well, you know, what is the point of us having these rules of judicial administration if these judges are not going to follow that, right? Why do we have this law? We had it for a reason.
Right.
There was a
agree,
reason.
But it's funny because I was talking to the Harris County District Attorney's Public Integrity Unit 2 days ago. And he's trying to tell me, well, it's the law. It's the law, it's the law, it's the law, it's the law. You don't understand law. And when he told me that, it made me even more frustrated. Mm-hmm. Because just like I'm communicating with you in common terminology, common text, right? Context, I'm coming to you in just the words that I'm projecting out of my mouth. I broke it down, just like you said. You have to spoon feed it to them. Sir, just like I'm telling you, like it's against the law, and you're telling me it's against the law. And remember, they use the law as their shield and sword. They use the law to protect them and to strike you, right? Mm-hmm. And then when we ask for the Constitution, oh no, it doesn't apply here. You don't know the law, Mr. Saldana. You can't read. You're not a lawyer. You didn't go to law school, right? Mm-hmm. You hired an attorney in the 60s because the literacy rate was so low. We needed someone who could read and could comprehend and who could project, right? And now in 2023, we have AI telling us how to write legal documents, right? So there's no way that you can tell me that I don't understand or comprehend what I'm reading when it says all felonies shall be forthwith before a magistrate of the county as per the Code of Criminal Procedure, Chapter 2, right? Yeah, Article 16. Go ahead. When I stuck the DA Public Integrity Unit, I said I am trying to file a felony, and there's no mechanism of reporting whether it's interference with child custody, aggravated perjury. There's no mechanism because if you go out to the streets and you ask any police officer or sheriff that you want to file aggravated perjury, they're going to tell you take it back to family court, and that's absolutely incorrect. Felonies go before a magistrate of a county. Now, so if you're going to use the law and say, well, under the government code, they don't have to do this. Well, as per the penal code and the code of criminal procedure, they have to do this. And what was his response? Well, I can't comment on that.
Mm-hmm.
So to me, it's very simple. Sometimes you have to be stupid, hyper technical, and you're absolutely right. Spoon feed them. And one of the things that we should add is that maybe everybody should download this and add it as an attachment with your Rule 12 request. Right? If you're not
yeah, at least quote part of it so they know that you've done the research, under sections 12.2, Judicial Records, section D, that's not that hard. Cut and paste and let them know that you know what you're talking about.
Yeah, but even when you file this, right, and you add it as an attachment, see attachment below.
Okay.
Right? You add this attachment with your email. Say, hey guys, I have it right here. You can't BS me, right?
Yeah.
Don't BS me. It's right here. If you don't know, if you can't read it, take it to the judge and have him read it, or have him reach out to the OCA. Have him reach out to the Office of Court Administration and let them figure out what he can release and what he can't. If we're not entitled to it, we're not entitled to it. But they shouldn't fight you along the way, right? If you're a judge and you believe in justice and integrity, and you're going to see all of these videos come out during election time. Hi, I'm running for the 37th District Court, and I believe in integrity, and I believe in professionalism and justice, right? And then they get into their seat, and all of that shit, down the drain. They just did it to get what they wanted, and then they don't care anymore.
Yeah. So it starts with the little things. If they're unwilling to even release one email, how do you begin to expect them to protect your rights, right? They don't even know how to follow the law and release an email. But if that's where we have to start and force them to learn the law, then I think it's worth it. So folks, I would encourage you to exercise this important right that we have our rights because people have fought wars over this. There's we're able to enjoy these things because of these sacrifices people have made in the past. So by all means, with pride, ask for emails from your judge and hold them accountable and appeal it, and just make that part of your routine. I'm yet to see a Tarrant County judge willingly release an email that they actually typed up. They think that that's somehow their property. George, if we can kind of wrap up, I want to kind of talk about maybe what we can talk about next time.
Honestly, I think we need to do a public information request soon, because Rule 12s are very, very important. But to me, I think public information requests, just knowing how to get those police reports, how to get certain videos and stuff, what's covered, what isn't. I think the public should know how to write a real, just like you did with the Rule 12, how to do an example of, or just give the people the ability to learn with an example of how to create a public information request.
Okay.
That I think that would be good, because now people can start looking into the funding. Where is the funding coming from in Tarrant County that they are making these rulings, especially with protective orders? Right now, protective orders, to me, I think are the new child support system, right? I think they know that the child support system is dwindling and people just think it's unconstitutional. And now VAWA, the Violence Against Women Act, is giving a lot of federal funding to counties to remove.
We're seeing that in Tarrant County. I just got open records requests back, so my mind's always thinking ahead. And I've asked for, all documents that describe federal grant money for issuing protective orders. And there's a lot. There's a lot more than I thought. There's a lot of federal money that comes in, that subsidizes. And there's two sides to this, of course. There's the district attorney side, the criminal side, and then there's the family court side. And I think what you would say is some of our biggest concerns deal with the family court side, because there's no obligation to have evidence. There's no protections, for the people to defend themselves. And but yeah, that'd be an interesting topic too. But yeah, you guys, you can use these things to find out where's the money coming from. Especially with the family courts, everything's driven by money and profits for the courts. We've looked up, Title 4D funds for Tarrant County, and they get about $3 to $4 million a year. That's just, imagine one little court. We got six family court judges, $3 to $4 million a year coming in. Like they're flush with cash. So there's a money incentive behind all of this. And then, what I would like to talk about maybe the following time, George, is some of these really big constitutional issues that civil rights attorney brought up, talking about allegations should be brought by the state, not your ex, not your angry um, there's a fundamental right to parenting that stems from a 1920 something Supreme Court ruling. I want to do some research to talk about what was that case like that established this as a fundamental right, and it's been that way for 100 years. So just something we can talk about in the future. All right, is that good, George? I think I'll call it to an end. Might be having some technical issues, but all right. Thanks, guys.